sadly, a problem arises.
Yeah.
Let's just take an example. In a construction contract, the company says it's going to put in triple glazing, and they put in double glazing. So what do we do about it? What's the first thing we should do?
Yeah, the first thing, if you found out there is a defect, or like if the liability hasn't been fulfilled correctly, you need to send a notification to the other party about acknowledging them that you found out there's a defect. And you have some rights. Either you can terminate the agreement, or you can ask them to deal with the problem, or you can ask them to change the good with a new one, a better one. So the first thing in your example would be notifying the other party.
Yes, and when lawyers always talk about notifications, and that sounds very formal.
Okay.
Does it need to be formal, or can I start off by just sending an email to the person and saying, "Hey, Burak, I've noticed that this house has only got double glazing in it, not triple glazing. What's going on? We'd agreed triple glazing." Is that a starting point? Is that enough?
It would be the starting point, because firstly the parties are trying to solve the problem, because as a Turkish mentality, going to court should be the last option
in any country.
Yeah. So they will try to sort out the problem, but obviously there's a time limit for notification and recovering your loss. So in the meanwhile, as a gesture of goodwill, you can make a communication either verbally or via email in the first place. But if you are not getting the reply back, a satisfactory reply back from the other party, then you should seek the formal way, which is sending a notification through a notary.
Okay. So you start off, phone call, "Hey, what's going on? There's a problem here." Follow it up with an email. But if you're not getting any progress, then you have to do something more formal, and the notification process is another thing that involves the notary.
Yeah, because why it involves notary, the idea behind it. If you're sending something with a certain wording and claims to another party, you have to prove that you asked for it.
Yes.
So with an email, actually we have a registered email system for the corporate entities, but it is not well working right now. So you cannot really claim that I sent the email, so they will say it's not working or something. Or if you send via normal post, you would never prove what was inside of that.
Yes. So it's just a way of making clear, first of all, that it's been sent, and second, that it's been received.
Yeah.
Now, and so how does the notary deliver the notification?
Through the post.
Yeah.
They use the postal system as.
But with an acknowledgement of receipt.
Yeah, you can get the acknowledgement of the receipt from recorded delivery as well.
Exactly.
But the only difference is, if you send it through the notary, you would have chance to prove what is inside.
Yes. And I know in Turkey, I'm going off on a bit of a tangent here, but I know in Turkey you have this amazing system, a population system, where everybody registers their address, for example. So the last known address of somebody should always be known.
Yeah, actually we have a registered address system for in two sections. The first one is for the private entities, like any citizen will have a registered address. Of course, there are some ways to get around the law. The second one is for the corporate entities. They are also registered within the system, so you will be able to see the registered address of the other party from the system. You cannot access it, but you can ask the notary to access it, or to court to access it.
Yes, you don't have personal right to see it. And so if the notary sends this notification to the registered address of the person concerned, that is deemed to be good, and you can then move on and do other things.
Exactly.
Okay, it's a bit of a tangent there, but so the notary sends this demand to somebody saying, "Hey, there's a problem here, we need to do something about it." And of course, in the real world, that causes the other person to wake up, because when they get the notarial notification, they realise that this is getting serious.
Correct.
And that they need to do something about it. So maybe they haven't done anything in reply to your emails, but they will do something, you hope, in reply to the notarial notice.
Yeah, the notary will is taken into consideration more serious action.
Yes. So what, if you receive a notice from the notary, what do you then have to do?
There is no have to do, because you can either reply to the notification or you may not, because you don't have to.
No.
But if you don't reply, basically you are just not accepting any content of the claims, any content of the letter. So, which means you don't have the intention of sorting the problem out as well. Yes. So basically, if you are not replying, you are just rejecting. So the other party will then go to court.
But what would you normally expect to happen if you received a notarial notice that something was wrong in the contract? What would you expect to do? Would you reply to the notary saying, "Thank you for your notice. I didn't know anything about this. I will fix it"? Or what would be the normal response?
The normal response would be, if they are rejected, we would expect them to send a notification back, replying the claims and with the rejections.
Yes.
So they don't usually accept in writing. If you are claiming something and they don't get back to you, okay, we accept the claim and we are going to be recovering your a loss or something. They don't normally do that. If they are accepting the claim, they will be presumably contacting you via normal, a telephone or email, and they will just fix it.
So they wouldn't reply to the notary, they would contact the other party to the contract.
Exactly. Because notary is just a middleman here.
He's like an expensive post office.
Yeah, I would say.
Yes.
But if they have some objections to your claims or the content of the letter, so we would normally expect them to write it back through a notary.
Yes.
So, yeah.
So this means that at this point you are clear that there is going to be a dispute.
Yeah.
And at that point it's over to the lawyers.